All right. Well, welcome everybody. My name is Glenn Cohen. I'm a professor and deputy dean here at Harvard Law School and the faculty director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. I'm about to introduce the panel, but before I do, I just wanted to share some logistical information. You can participate in this panel by submitting questions at any time using the Q&A function. You can join the conversation on Twitter at Petrie-Flom using the hashtag Dobbs. If you have technical issues, we have an email address to connect to, and we highly recommend joining our newsletter for more information on more events. All right, so now let's begin the substantive business. So Friday was, of course, a seismic moment in constitutional history, and indeed in American history, as the Supreme Court released its opinion in the Dobbs case. I can't think of a moment in my lifetime quite like it. The decision, not unexpectedly, has yielded incredibly divergent reactions, not just across the political aisle, but even on a campus like Harvard's. We've assembled the leading experts in law, medicine, and ethics to explain the decision, situated in the Supreme Court's history and the history of abortion rights, discuss the implication of the court's decision for the future of reproductive rights, privacy, healthcare, and discuss where constitutional law more generally goes from here. I'm going to introduce the panelists. They're each going to have a first round where I'm going to ask them a question. We'll then move to a second round where we'll have questions offered to all of them, as well as questions drawn from you submitted in the Q&A function. And I'm going to give them the briefest of introductions. If you want to learn more about them, we have links out to them in their bios in the invitation. All right, first we'll hear from Jeannie Gersen, who is the John H. Watson Jr. Professor of Law here at Harvard Law School. Then Noah Feldman, who's the Felix Frankfurter Professor of Law at Harvard Law School. Then Mary Ziegler, who's a professor of law at the University of California Davis School of Law, but who was a visiting professor here at Harvard this past semester. And finally, Dr. Louise P. King, an assistant professor of obstetrics, gynecology, and reproductive biology at Harvard Medical School. So with that, we're ready to get started. And Professor Sue Gersen, I'm going to start with you. As anybody who reads the New Yorker knows, you're one of the most gifted people in explaining the significance of a legal case. Can you describe what the Supreme Court decided in Dobbs and help situate it in debates on constitutional theory?
Certainly. So we did know that the Supreme Court was going to overrule Roe versus Wade, and because of the leak in the beginning of May, and now that has happened. So in the ruling, Justice Samuel Alito, joined by 5 justices in the 5-justice majority, Justice Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, declared that there is no constitutional right to abortion, and therefore the states and the federal government now have the power to restrict the abortion procedure or access to it as they wish. So I wanted to say a few things about that were notable to me about the opinion. We know that the method that the Alito opinion used was originalism. And that method is one that he said limits the 14th Amendment's meaning to a certain version of the legal past, a particular slice of the legal past. So taking the language from Washington versus Glucksberg, which is a 1997 case that said that the 14th Amendment's guarantee of liberty refers to fundamental rights that are deeply embedded in the nation's history and tradition, Justice Alito then interpreted the history and tradition, specifically the legal history and tradition, in a particular way, and he found that there is no right to an abortion deeply embedded in the nation's history and tradition. And so therefore, the Due Process Clause does not protect the constitutional right to abortion, that there is no such right, that Roe was egregiously wrong from the day it was decided because it neglected to understand the correct way to interpret the meaning of liberty. So a couple of things I want to say about that. We have had a long-running debate that we've seen for decades in the area of substantive due process between conservatives and liberals on the Supreme Court. And that question is, how do you define the liberty right that is at stake when you're talking about the Due Process Clause and the guarantee of liberty? What does liberty actually mean? And of course, the Supreme Court's job has been to give meaning to the words of the Constitution, including the broad concept of liberty, one that is not particularly defined in the Constitution. So one method, of course, has been associated with the conservative justices, and the idea is to narrow the question and the definition of liberty so that you would ask a very, very pointed question like, is there a right to abortion that is deeply embedded in the nation's history and tradition? And when you define it at that very low level of generality, what you're going to find, and what the court did find here, is that the right to abortion specifically is not, in fact, represented robustly in the nation's history and tradition. However, the liberal justices over the decades have advocated for a way of interpreting liberty that is much broader than that you don't specifically ask about the lowest level of the activity at issue, but rather you think about it in terms of broader concepts such as privacy and maybe bodily autonomy, the right to control important decisions about your life. So the framing of the question is often outcome determinative, and that is what we see here. The other thing is that Alito ties down the Constitution's protections for liberty largely with reference to laws that date to mid-19th century America. And we know that during that period, there was a campaign to ban abortion. And so that history of trying to ban abortion, the campaign to ban abortion legally, plays into the support for Alito's idea that it is not supported by the nation's history and tradition. And the implication that the Constitution only protects liberties that were protected during that period when women couldn't vote or practice law, or wives couldn't control property or their earnings, that was the period that the definition of liberty is tied to in the Dobbs opinion. Glenn, I know that we have limited time and there's much else to discuss, but I think I'm going to turn it back now that I've pointed to a few things from the majority opinion.
Thank you, Professor Gersen. We'll come back to you during the open round. Professor Feldman, you're next. So you've written a book about another fractious period on the Supreme Court where the justices couldn't, reach agreement on many things. I wonder if you could tell us a little bit about the various factions of the court, the ways in which the Dobbs decision fits into other recent decisions, and what this means for the institutional legitimacy of the court.
Building on what Professor Gersen said, I think the crucial thing to understand up front is that the conservatives on the court, and there's some diversity amongst them, are in a historical process where they are trying to implement originalism in a wide range of areas, destroying pre-existing constitutional doctrine to do so. You could think of this as the last 10 days as the Corleone family is settling all its debts. They're out there trying to kill off crucial lines of doctrine. They did it in the context of guns. They did it in the context of church and state. And of course, they did so most importantly and famously in this context. And that's a product of the fact that there have been a few conservative justices pushing for that kind of revision of the whole body of constitutional law for a long time, but they didn't have the votes to get it done. In that sense, Justice Thomas is in some ways the most influential member of the court right now. He's also the most conservative member of the court. For many years, it's been Justice Thomas's view, which he expressed usually alone in solo opinions, that it doesn't matter what the Supreme Court has said in the past about what the Constitution means. It doesn't matter what the precedent is. All that matters is go back to the original meaning of the relevant clause of the Constitution and apply that. Damn the consequences. He would put it, let justice be done, even if the heavens should fall. I don't particularly think it's justice, but that's the principle that he's trying to express. And what's happened is that over time, that view, which was thought of as a peripheral view, even by many of the court's other conservatives, has been mainstreamed. And that's what's happening here. In order to get there, the three appointees of Donald Trump were all necessary. All of their votes were necessary. And that is because Chief Justice John Roberts, who is the least conservative of the conservative members of the court, has pushed back against the Thomas approach and said that in his view, the institutional legitimacy of the court depends on it exercising judicial restraint. Now, to be very clear, the Chief Justice is still very conservative. His separate opinion in the Dobbs case would have upheld the Mississippi law and would have overturned Roe v. Wade's viability framework. But consistent with the Chief's preferences, it would have done so without saying that it was overturning Casey, and it would have still allowed the possibility, at least, that abortion rights prior to 15 weeks remained in place, pending a future case where the court could have reached a different result. So in a world where that's one of the most liberal opinions in the court on a case like this, that tells you how far things have gone. Last but not least, and this is really important for understanding the factions on the conservative side of the court, Justice Brett Kavanaugh, who is the least conservative of the hardcore conservatives, that is to say, only John Roberts is a conservative who is more liberal than Kavanaugh, wrote an important concurring opinion here in which he addressed some of the issues that we'll be talking about today. For example, he addressed the question of whether states could constitutionally prohibit their citizens from crossing state lines in order to get an abortion. And he said, in my opinion, the answer to that question is simple, and the answer is no, the states can't do that. So what Justice Kavanaugh was doing, and it's very unusual for a justice to address a constitutional case that has not yet been brought before the Supreme Court in an opinion concurring, what Justice Kavanaugh was doing is he was binding himself publicly to the view that he will be voting to say that a state may not prohibit someone from crossing state lines for purpose of an abortion. That's an attempt to calm things down. I'm not saying it's a successful attempt. My guess is it's not, but it's an attempt on his part to try to calm things down, because assuming that Chief Justice Roberts remains where he is, Justice Kavanaugh's vote would be necessary to uphold any such state restriction. Without him, it is effectively certain to fail. So what Justice Kavanaugh was doing was trying to signal that he is not on board with all of the other conservatives. Last point here on the dispute between what you might call the Thomas wing of the conservatives and the Kavanaugh wing of the conservatives. In his opinion, Justice Thomas also said that he thinks we should be revisiting all of the other fundamental rights which the Supreme Court has declared under the Due Process Clause of the 14th Amendment. That includes the right to gay marriage. It includes the right to have sex with a partner of your choice, regardless of that person's sex or gender presentation. It includes the right to contraception. It even includes a right against forced sterilization. So a whole range of intimate and reproductive relative rights. So Justice Thomas didn't pull any punches. He said, I think we should revisit all of these. Justice Kavanaugh, in his concurrence, made the point that he does not believe that those things need or should be revisited. What that led to, and this will be my last point, is in the rejoinder from the court's three liberals, all of whom joined the opinion together. They did something unusual. They signed an opinion under all three of their names. In that opinion, the justices on the liberal side say, we do not think it's appropriate to take the court at its word here. Even if the justices are telling the truth about saying they're not going to revisit those other rights, the way that Supreme Court opinions work is that they have a certain logic. And if you were to apply that logic to those other substantive due process cases, then just as Professor Gersen pointed out, there is not really a strong constitutional basis for those other rights any longer. So that's what the dissenter said. And I should just note that on a very, very close reading of that opinion, although bits and pieces of it sound like Justice Breyer and Justice Sonia Sotomayor, the overwhelming majority of it, I would say roughly 90% of that opinion, sounds like Justice Elena Kagan. It's in her very distinctive style of writing. And because her style of writing is so distinctive, I think court watchers probably would all agree that she is the primary voice there. But as I say, they've all signed it. So the takeaway is we're at a point in the history of the court that is an inflection point. My own career in constitutional law will have a BC and an AD part, with BC being everything before Dobbs and AD being everything after Dobbs. That I think will be true of a lot of us who are in this field. And it's a moment when the justices are changing the rules of the game, and they are in deep disagreement as between the five hardest line conservatives, the three liberals, and in the middle, Chief Justice Roberts, who unfortunately looks a bit like a person without a country at this point. His views in favor of legitimacy simply were not heeded by the court.
Thank you. Professor Ziegler, you're probably America's most gifted historian of abortion. Can you say, I know you've written books on the subject, so I'm asking you to do a much briefer version. Can you tell us a little bit how we got here and what we can learn in terms of political advocacy and political movements?
Yeah, I mean, I think there's sort of structural things that helped bring us to this moment. So I think obviously the creation of a conservative legal movement that I think will blunt some of the public response to this opinion. I think that the Supreme Court is being celebrated in certain quarters for what it's doing, which I think makes the professional costs of an opinion overruling Roe that might have seemed unimaginably high to a court in the 1990s when Casey was decided are probably no longer that way. I think the polarization of the country writ large, in particular kind of political party realignment that we see realized in the South, in state legislatures in the 2010s and at the national level in the 80s was part of it. But of course, there's a social movement history here too. And the Dobbs opinion really closely tracks arguments that have been made by pro-life or anti-abortion folks since the 80s. You see in Justice Alito's opinion and in Justice Kavanaugh's concurring opinion, the idea in part that Roe should be overruled because it failed to settle the abortion issue, right? Essentially the idea either that as a historical claim that Roe polarized the abortion politics or even kind of created our culture wars or politicized our Supreme Court confirmations, which is an argument that really doesn't have much historical support. There are no professional historians who've documented this or attached as much significance to Roe as Alito and Kavanaugh do, but that is an argument that's attracted a lot of attention in social movement circles. There's an argument that Roe and Casey failed to settle the abortion issue, and that we can document this by looking at the resistance of states to Roe and Casey or the existence of the anti-abortion movement. This kind of argument that the existence of resistance means a precedent is unworkable or failed to settle a dispute is an argument we can trace to the pro-life or anti-abortion movement. So this, in some ways, I think folks in that movement have compared their cause or their fight to kind of long-standing litigation campaigns like the NAACP's effort to reverse Plessy versus Ferguson and Brown versus Ward. Obviously, I'm not sure in some ways I'm sympathetic to that analogy, but there is a sort of similar kind of long-standing supplying of arguments, chipping away at the coherence of Roe that could create some of the reasoning we see in the opinion and a kind of hollowing out of abortion rights. I think that anti-abortion lawyers argued it kind of lowered the stakes of what was effectively the destruction of a constitutional right. I think there was an argument that this right already meant so much less because the Supreme Court had already upheld so many restrictions, either that suggested that the right was unworkable, that the justices had tinkered with the right so much that they must have thought that it was somehow infeasible or unworkable. And I think that, American people couldn't rely on the right because the Supreme Court had signaled that there was something wrong with it and enough wrong with it, at least that it needed to constantly be adjusted and refined. So I think that, as is often the case with stories like this, it's a story about broader changes in our polity that go beyond what any kind of movement could control. But it's also a story about how constitutional law is made, not just by the justices, although certainly I think Professor Feldman's absolutely right that to understand what's going on, we need to understand the factions on the court. The court's always in dialogue with movements and with political parties too. Of course, this is also a story about the partnership between the pro-life or anti-abortion movement and the Republican Party. It's a story of how the Republican Party's approach to Supreme Court confirmations has changed in profound ways since the years when Justices O'Connor or Souter or Kennedy were chosen. We've seen a kind of move toward nominees that were designed to energize the conservative legal movement or even energize a certain subset of voters, confirmation battles that are much closer fought and often more divisive. And so there's no simple answer to how we got here, but I think if you're in law school and you're wondering kind of what can you learn from this, certainly social movement lawyering matters, but so do broader politics, right? This is if you're thinking about what to do with your law degree, how this kind of change was effected was not just through litigation. It was a much broader story than that.
Thank you, Professor Ziegler. Dr. King, besides your academic appointments, you're also a practicing surgeon. You're also the vice chair of the ethics committee of the American College of Obstetrics and Gynecology. I wanted to ask you what you see as the immediate impact of Dobbs on the ground is. I know you're getting a lot of these phone calls as we speak, and also what you think the longer term effects are for people who practice in OBGYN.
Thank you. I'm so grateful to be a part of this and listening to each of the experts speaking. I've already learned so much. And what I noticed is missing, and I understand as a lawyer why it's missing, is a discussion of the answer I'm about to give you. ACOG and many other interested parties submit amicus briefs every time these cases have been brought up. And if you review the opinions and the citations and the considerations, the thought process around what this actually means on the ground is never a part of this discussion. And again, as a lawyer, I understand why it's not, but it's disheartening as somebody who faces patients daily facing these agonizing decisions at times, and potentially now facing life-threatening decisions, that does not represent a part of the calculus that comes into play. I wish it did. But the immediate effect is that women will die, persons who are pregnant will die. When these laws do go into effect, and in states in which abortion is restricted, the laws are vague enough and refer to medical emergency and refer to reasonable belief, and to give us guidance on when we can intervene. I can give a number of examples, and they're flying around on the internet and on social media, but ectopic pregnancy is an issue in play. When a patient typically presents with an ectopic pregnancy, they're usually stable, and so they do not constitute a current emergency. And so, although we would typically intervene immediately, many of our interventions are medically based ahead of the emergency happening. We can't use those in restrictive states, potentially. To operate, I might have to wait until someone's hematocrit drops, until their vital signs become unstable, until a certain organ system is affected. The story of the young woman who died in Ireland from a septic abortion will become a story here in the United States very shortly, because again, sepsis moves very, very slowly until it doesn't, and then it kills. And it's only at that inflection point that we could, in these restrictive states, intervene. And at that point, it might be too far gone. So in the immediate moment, we will see physicians facing these dire consequences and these decisions for which they have little guidance under the current restrictive legislation that will go forward. The moral injury of being faced with that will lead to many, many more of our colleagues in the profession leaving the profession. If they are prosecuted, they will not be able to provide care to all of the patients that are coming through our doors. And so even further, we will see more deaths as a secondary consequence of this. I wish that weren't the case, but it truly is what we're seeing. In terms of steps forward, longer term, the only hypothesis that I can conceive of would be to go forward to attempt somehow to have preemptive guidance from any of the lawmakers who have created this legislation, or AGs in the states in which these restrictive laws will be in process or in effect, because we need more guidance to know when we can and can't intervene under these restrictive laws. And then within the states, like our state here in Massachusetts, we are, of course, gearing up, as is California notably, to accept patients from out of state as they travel to us to receive care. Notably, a large portion of people who are the most deeply affected by this decision and its ramifications will not have the resources either to seek this type of assistance or to pay for it. I mean, they might not even know how to seek it out. So again, as is frequently the case in our current times, those who are already suffering the most will suffer further.
Thank you, Dr. King. So we're now going to move to a panel discussion where we're going to be answering some questions, including questions suggested by the audience. Be able to just feel free to jump in among the panelists. I want to start with actually medical abortion, as it's sometimes called. And this may not be well known to many people across the country, but actually a large number, maybe even the majority of abortions in America are actually medical abortions, a two-drug regimen, mifepristone and misoprostol. And I guess I want to ask you a little bit about what's going to happen to medical abortion in restrictive states. So Attorney General Garland came out with a statement suggesting, FDA believes that its approval of mifepristone and maybe the REMS, which is some regulation of how it's prescribed and the like, binds and will apply in states. It raises legal questions of preemption. I'm curious if any of you have views about whether this is likely to succeed or whether medical abortion will equally be hammered in the states where abortion in general is being restricted.
Well, I'll jump in. Certainly, I can prescribe over state lines and would be happy to do so. Whether the person I prescribe the medication to can actually access the medication is a huge question. Can we ship it? Probably. I don't know for sure. But the bigger question for me is when I prescribe medications like these for somebody who is going to undergo a medical abortion, the complication rates are exceedingly low. But when they do occur, they present as heavy bleeding, hemorrhage potentially requiring assistance and care. And so if you are still in a state in which there is restrictive laws in place, your ability to receive care for that hemorrhage may be compromised. And so then what is my duty if I'm prescribing that medication to you when I don't know that you have access to subsequent care for anything that might ensue thereafter? This question is also important to any pregnant person who's choosing to travel to a restricted state who's currently pregnant. They will have to rethink, are they going to take that trip because they might not be able to access care if an emergency ensues. And that applies specifically in my collegial work to conferences and all of the like. So it's a complicated question, and I don't actually know the answer exactly.
I would just add a sentence to that. I would just add a sentence to that, Glenn, which is that, and it's very helpful to hear it from a physician's perspective. There's going to be litigation about this. I think that's the simplest way to put it. The preemption position that was very briefly suggested by the Attorney General is a defensible one. And I think there are very strong legal arguments in support of it. I certainly support that view myself, but there are also legal arguments that will be mounted on the other side. And I would be stunned if no state legislature actively prohibited the use of medications that can bring about medical abortion. So given that, it's likely that we'll have, among the many, many, many other topics of which there's going to be ongoing litigation that we're going to be following closely in the news for the next, I would probably say 3 to 5 years. I think it's very probable that it's certain that this will be litigated.
Yeah, and I think there's a lot of uncertainty about the outcome. I mean, even the Attorney General's sort of nod at the preemption argument is worded kind of ambiguously. Essentially, the idea would be that if FDA has weighed in on saying this drug is safe and effective, that's the final word on the matter and states can't contradict it. I imagine states are going to try to look for kind of potential openings in FDA preemption jurisprudence about the bases on which states are regulating abortion medication, more moral grounds than safety or efficacy grounds. And I think Professor Feldman's right that there's a lot of uncertainty about how those disputes are going to come out. We know eventually they'll end up back in the courts. And if there may be, if this court is unsympathetic enough or sympathetic enough to states regulating abortion and unsympathetic enough to the idea of abortion, that may or may not shape how they react to the preemption argument. But I think that there's enough of a legal gray area here that will invite litigation. That alone will invite litigation. And I'm 100% sure, because states have already been doing this, that they are going to regulate medication abortion in the abortion bans they already have in place in the trigger laws and pre-Roe bans. There are some states that are making more explicit that they're going to place additional regulations on abortion medication, whether that's attempted bans on importation or usage, such as we're seeing in South Dakota now. So, there's going to be not only an extension of existing abortion laws to medication, but I think, if anything, is zeroing in on abortion medication, which people who in conservative states, I think, correctly view as the major battlefront to come in a post-Dobbs America.
And I'll finally just end by saying the fantasy of the Supreme Court getting out of this space will become extremely clear very soon. That the idea that now it's up to the states and the democratic processes and the courts are now done with the issue. This is just the beginning of the courts being ensnared in all kinds of debates that go to very deep issues of when people think life begins.
Thank you all. And I'll just add, there's at least one private lawsuit pending already that I know of on the preemption of restrictions on mifepristone. We've got some questions in the Q&A from the attendees regarding, I'll put these two together, in vitro fertilization and embryo destruction connected to IVF and contraception. I wonder if you have views, both as a matter of constitutional law, but as a matter of state politics, whether these are battlefronts where we're likely to see restrictions and how challenges to such restrictions will fare.
I mean, yes, right. There are going to be challenges. We've already seen a Catholic hospital in Kansas City saying that it's no longer going to make emergency contraceptives available because of ambiguity that it sees in Missouri's definition of abortion. There's a long history of contestation over the meaning of the word abortion. So it turns out that we haven't just disagreed about whether abortion should be legal or illegal, but also what abortion is in the first place, especially as it pertains to IVF and contraception. Some states have, I think, tried harder to define abortion in their bans in ways that explicitly, for example, exclude IVF or certain forms of contraception. Other states have not, and have instead incorporated definitions that focus on sort of borrowed from the personhood aspect of the pro-life or anti-abortion movement, right? So the idea that life begins at fertilization, that definition could apply to IVF or to birth control. There are people in the movement who think that it should. There are state legislators who think that it should. This should bring to mind conversations about the contraceptive mandate of the Affordable Care Act, which of course harkened back to this idea that some forms of FDA-approved contraception are abortifacients or abortion-inducing drugs. And so I think there's going to be a lot of unpredictability and probably some litigation here too. And I think probably also compounded by the fact that in most states, the pro-life or anti-abortion movement is fracturing. There's less of a kind of top-down hierarchy dictating what policy is going to look like. And so disagreements about the desirability of regulating emergency contraception or IVF are going to matter more when there is no sort of single entity or wing of the movement that can call the shots in terms of the types of state legislation we're likely to see.
I think we're going to see more internal dissent in the movement, I think, as Professor Ziegler is suggesting. And not just dissent among the pro-life or anti-abortion movement, but also just the people on the ground. I mean, it's one thing to rail against a Supreme Court decision that you think, that if you're a pro-life conservative, think that has, usurped power from Democratic majorities to the Supreme, arrogated power to the Supreme Court to decide these fundamental issues for 50 years. If you think that, and it's one thing to rail against that and be active in protest against that for 50 years, but it's another thing to say, going forward, what I want to accept is to live in a state or a society that does not allow basic things like abortion and like medication abortion and contraception and activities like reproductive technologies. So I do think the reality is at some point going to hit the actual Democratic majorities who have to live with these decisions.
Great. Go ahead, Professor Feldman.
I was just going to, again, echoing both Professor Ziegler and Professor Gersen, as we try to anticipate what the new reality is going to look like, there is a scenario in which the legislation, which is going to be is already extremely radical in terms of its constraint on reproductive freedoms, actually is implemented systematically in a way that has a tremendous impact on the ground on nearly everybody. And in that environment, the kinds of debates that Professor Gersen is describing within the pro-life anti-abortion movement will have to be fought out. There's also a scenario where enforcement is less aggressive in practice than it is in theory, and in which people are able to travel to other states and or receive medication that would enable abortion. In that scenario, there's still a tremendous series of problems for the poorest people who can't travel easily across state lines, some of which will be addressed by NGOs and other charitable donors trying to make medication more easily available, but some of which will not be. But in that scenario, we could emerge with a quote unquote new normal in which the pro-life movement doesn't have to fight these fights at that most basic level with respect to the unpopularity of the consequences of their position. And so that's, I think, for those who are interested in following this issue going forward, which I think should be everybody, that's the thing really to watch, in my view. Will we find a normal in which enforcement is relatively lax so that de facto the pro-choice movement is able to avoid deeply unpopular actions beyond what it's already done? Or do we expect to see a world where there is more aggressive enforcement, in which case, as it were, the anti-abortion movement will have to internalize the costs, the externalized costs of what it's done in getting the court to overturn Roe and in getting many state legislatures to outlaw abortion?
So I want to pick up on that last thread. Sorry, Dr. King, go ahead.
I apologize. I'll try to be really quick.
No.
But, the idea of a world in which there's less enforcement, but I'm still left not knowing what I can and can't do is not particularly appealing to me. So I'm certainly not going to back down until I have a world where I know what I can do. And you're absolutely right to put contraception and IVF together, because if I'm going to go through an IVF cycle with someone, I need contraception to time things. And I need abortion because IVF is frequently associated with miscarriage, which can occur when electrical activity or heartbeats are present. So I can't counsel a patient in a restrictive state to continue with IVF. It's dangerous. Or I don't have access to the appropriate medical procedures to proceed forward. So I need solid ground to stand on to ethically move forward with these necessary assisted reproductive technologies.
Yeah, and I think the only other thing I'd add is in terms of other fault lines, there's a little bit of a debate unfolding about the extent to which the solution in states that are strongly opposed to abortion should be incarceration, right? Should be, and it's worth emphasizing, criminal penalties, unlike anything we saw in the 19th century, right? So most of the criminal penalties in the 19th century were in the ballpark of like 3 to 5 years in prison. And that was sort of often the maximum, not the actual sentence. We're seeing in some states with trigger laws or kind of other penalties, 10 years in prison, life in prison, 99 years in prison. So the solution is either more incarceration or kind of more ingenious forms of enforcement of existing criminal laws, right? Better surveillance, bounties, et cetera, or whether there needs to be more on the kind of other side of kind of supports for pregnant people. At the moment, that's difficult for a movement that's aligned with a party that's wedded to the idea of small government. So most of the sort of support side solutions you see states offering at the moment are more along the lines of information about existing resources that are private, charitable, and ultimately at the discretion of the actors running the charities. But you are beginning to see some question of, if you can't enforce criminal laws, is the solution to stop trying to enforce criminal laws and to look instead at a better social safety net. I haven't seen much sign that that's where we're going, but I mean, that is another, I think, debate that's probably going to be unfolding as states realize that it's going to be very different to ban abortion than it's going to be actually enforce a ban on abortion in a world where medication abortion is available.
So thank you. So now I have two separate threads from what you've said that I want to pull, but I'll do them in order. One I'll come back to in a moment, which is about interstate travel. The one I want to pull now, and both of these are from the Q&A as well, is the question about the target of enforcement and the target of criminalization. So it used to be at once upon a time something of a, not imperfect, but something of a red line that the criminalization always focused on providers, not pregnant persons. I think we're seeing that wiped away a little bit, and I wonder if you could comment on that. And relatedly also, criminalization or enforcement against those who assist. So there's been lots of discourse about employers potentially helping to pay people to travel. This is, of course, is an imperfect solution. There's many people who, for many reasons, can't travel, including being people with some kinds of disabilities. But I'm curious whether you think that the target of enforcement is going to shift from providers to others, and how likely that is, both as a political matter and a legal matter, to make a difference.
Yeah, I mean, it's shifting. So I think the larger universe of so-called accomplices is already happening. So one thing to notice, the National Right to Life Committee, which is, I think still, if I'm not mistaken, the largest national anti-abortion group, put forward model legislation that defined accomplice liability in pretty exceptionally broad ways, kind of right up to the line between speech and conduct. So if you, for example, have a website detailing how to use abortion medication, you would be guilty of accomplice liability and guilty of a felony. If you were an abortion doula, you would be guilty of a felony Jeannie, there's sort of a disclaimer in part of the model law saying essentially this would not apply to pure advocacy for abortion rights, but would apply to a lot of other stuff that still, I think, may get First Amendment protection. So there's been a strong push toward defining accomplice liability broadly, in part because conservative states at the moment are still trying to adhere to this commitment to not punish pregnant people themselves. Having said that, there's a rising wing of the movement called the abortion abolitionists. This sort of grew out of the folks who were the kind of law-breaking clinic blockade movement of the 80s and 90s. The abolitionists now have model laws they're promoting in a lot of deeply conservative states that would not only define abortion to include things like IVF and contraception, it would authorize the punishment of pregnant people directly and for homicide-like offenses, right? So not just authorizing punishment, but authorizing quite serious criminal punishment. And the abolitionists are no longer as fringe as they once were. We've seen abolitionist-style bills at least make it through hearings in the state of Louisiana. We've seen abolitionist-style resolutions passed by majorities at the Southern Baptist Convention, which is, of course, a huge force in the pro-life or anti-abortion movement. And we've seen a lot of people just say on practical terms, if people can order medication on the internet from Europe and those doctors in Europe cannot be extradited, what choice do we have as legislators if our goal is incarceration and punishment, but to punish the pregnant person? So I think while at the moment pregnant people are not the ones in imminent legal jeopardy, there are a lot of, I think, factors both within the anti-abortion movement and kind of logistical questions that state lawmakers are facing if their kind of strategy of choice is harsh punishment that could put pregnant people in the line of fire, I think, in the months and years to come.
Glenn, could I just add to that with respect to the corporate involvement? I think one really important, again, subject to watch is going to be the way that corporations are responding to the Dobbs opinion and the subsequent legislation, but also the way that they are being drawn into the public debate to some degree against their will in some cases. I think Lyft received a letter which has been made public from a group of Texas legislators, not the whole legislature, effectively threatening criminal liability, not only for their company for sending people out of state for abortions, but even executive leadership. And the legality of that, leave aside whether anyone would actually do that, whether a state legislature would actually do that, the legality of that is, I think it's fair to say, an open question. Unlike the question of a person traveling out of state to receive an abortion, which Justice Kavanaugh said in his view is an easy constitutional question. He didn't say anything about, and it would not be the same question, of whether a private corporate actor could be held liable for paying for someone to travel out of state for conduct that is not lawful within that state. That's an open legal question. So I think the first question is, how far are state legislatures willing to go? And the answer may be that if those state legislatures have gain to be had through confrontation with corporate actors, in the way that in a different context, for example, the Florida state legislature was happy to engage with Disney, passing what I think is an obviously unconstitutional law, punishing Disney for taking a stand against the Don't Say Gay law, then it's reasonable to assume that other state legislatures, Florida and elsewhere, will have a similar view with respect to targeting corporations. So that's yet another domain in which this will be fought out. And although it's important to note that it's one step removed from the direct regulation of pregnant people, it nevertheless has serious implications for people whose healthcare is paid for by large corporate employers.
Great. So I want to just pull one more time, sorry, Dr. King, on this thread about interstate travel. So I guess if Brett Kavanaugh says it's an easy question and there's 5 votes for it being an easy question, it becomes an easy question. But I have to say, you'd asked me a few days before the Dobbs question whether I thought it was well settled under constitutional law that you couldn't have extraterritorial criminalization of an activity that begins in a state. I would have said, I think this is tough and I think this is going to be litigated. I'm curious whether you think that this is now just settled because of the concurrence, whether you think this is going to be an area where we're going to see a lot of litigation, if anybody has views on this.
Well, I definitely don't think it's settled, but I look forward to hearing everybody's views. And it's of great concern to all of us who are practicing this type of care and caring for these patients. And just to build on some of the discussion of how pregnant persons might find themselves, whether they're traveling across state lines or staying within their state, in fear of criminal prosecution, I have no doubt that there will be significant attempts to criminalize the behavior of pregnant persons, as there has been over a great period of time, as documented by our colleague Michelle Goodwin, and certainly in a different context. But there's no question in my mind that state legislators will go after criminal actions against pregnant persons for abortion, and will try to go across state lines. I'm looking forward to hearing your thoughts, though.
I mean, I don't. Oh, go ahead. You go first.
It may be settled in Justice Kavanaugh's mind for himself, but that does not mean that legislatures, state actors will make this attempt and push this issue. If we learned anything in the past year, we have learned that what the Supreme Court has said in the past, let alone what one justice has said in the past, is not a guide to what litigants and states in this space have taken to be the law. And so our experience, I think, with Texas SB 8 has shown us that where people believe enough in the righteousness of their cause that they are willing to get around even what the Supreme Court has said in the past, they will try to do so, and they'll try to come up with ingenious ways in which they can. And there really is no guarantee that, even though Chief Justice Roberts said what he said in his concurrence, essentially that he wouldn't have overturned Roe versus Wade outright, that doesn't mean that he wouldn't join, say, 4 others if Kavanaugh were to defect on this one, on the question of interstate travel. So I do not think in any way that this should be taken as we're done, we're fine with this.
Yeah, I mean, I think something Professor Feldman said was spot on too, in the sense that no state is actually saying you can't travel to get an abortion, right? This is all, as Professor Cohen was saying, about extraterritorial application of criminal law, usually on the provider side, right? And so I'm not even entirely sure we can read Justice Kavanaugh saying all of those questions are easy as pertaining to providers, to corporations, and so on. There are lots of questions about choice of law and the right to travel that are not just directly about states saying, hey, you can't travel to get an abortion, which to my knowledge, no state is saying they want to do. There's been several states saying that they want to try to permit either lawsuits or criminal prosecution of doctors in states that are performing abortions that are legal in the boundaries of those states on citizens from states where abortion is illegal. But I'm not even entirely sure that's what Kavanaugh is talking about. And if it is, I don't see how either constitutionally or as a matter of choice of law, that's an easy question. I kind of don't believe Kavanaugh thinks it's an easy question either. So I agree very much that we can't predict. Those issues are not at all settled, and I think will almost certainly be litigated. And we've already started to see lawmakers in several states suggest that that's a direction they want to go. So I think it'll probably be sooner than later that those questions arrive in court.
Without trying to cause any panic, I also would note that in the dissent, one of the lines was, in case Congress should pass a law outlawing abortion, the question would no longer be, can you go to New York or Los Angeles, but can you go to Toronto? But the truth is that legal question is even more worrisome, because if there were, heaven forbid, to be a law passed by Congress outlawing abortion anywhere in the United States, there is some precedent to suggest that Congress can apply US law extraterritorially to US citizens, which would mean that a Congress that did that would certainly try also to outlaw travel abroad for purposes of having an abortion. And since the court has upheld laws that, for example, make it a crime to travel abroad for purposes of engaging in sex with minors, as legitimate extraterritorial applications of US law, you could imagine this court upholding such a law, which is not to say there wouldn't be arguments against it, but there would be, it's clear what the argument in favor of such a law's constitutionality would be.
Great. So we have about 10 minutes left. I want to reserve 4 minutes for one last question. So I'm going to give you another question now before we get to that one, which is about politics. So I'm curious both, what do you think the administration should be doing, what you think of what they are doing, and also how you think this issue will manifest itself in the midterm elections? There have been proposals to open up federal land for this. There's, of course, some action on mifepristone. There's some other conversations now happening in the public sphere, a lot of private conversations as well. I'm curious if you have thoughts about how the federal government is reacting so far.
Well, one consequence of the leak was that the Democrats have already had the internal fight about whether there would be congressional support for sufficient congressional support, specifically in the Senate, for a law that would attempt to overturn effectively Dobbs statutorily. And there wasn't sufficient support for that. So what we should be hearing about, what we ordinarily would be hearing about now, would be the question of whether Congress would pass such a law. Then it would have to be litigated because unquestionably it would be challenged in the courts. But we're not even having that conversation at all. So from that perspective, the conversation is really impoverished relative to what one would have expected. But the reason is that that part of the conversation, as it were, has been had. There may be other creative ideas that people can come up with. With respect to the midterms, Ben, I'll just say super briefly, it remains to be seen how Dobbs will affect turnout. It will affect turnout surely for people who are upset about the outcome, but it will also presumably affect turnout from those on the other side who are happy with the outcome and want to assure that Congress doesn't, for example, expand the Supreme Court in such a way as to overturn Dobbs. Where I expect to see the biggest political change, and this remains to be seen, of course, though, is that should the Democrats at some time in the future, probably not after these midterms, control the Senate, the House, and the presidency by significant margins in the case of the Senate, the pressure on the Democratic Party to push for court packing will be far, unimaginably higher than it has been heretofore. And so I think that would represent a major challenge for the Democrats as they try to figure out what to do. But at the present moment, you're not hearing a lot about that because I don't know too many people who expect that the upshot of this midterm is going to be that the Democrats are going to consolidate greater control of the Senate and the House.
I will say that, I think Professor Feldman used the word impoverished to describe the post-Dobbs reaction from, say, the other branches of government, the federal government. And part of what I think is happening is that even though we knew this decision was coming down, this is kind of the result of several decades of our reliance on the Supreme Court to guarantee our liberties. And we're kind of out of practice for a variety of reasons, one of them being that we expect the Supreme Court to be the one to basically decide these fundamental issues. We're kind of out of the habit of thinking that Congress can actually get things done. And practically speaking, right now, it doesn't seem like there's a lot of will on the part of Congress to get this done, to actually say that this is a right that we care about and that the American people should have. And so I think that it's kind of a wake-up call just on a larger level, not just on this abortion issue, of how much our society has become so Supreme Court oriented. And I think it's a wake-up call that will end up, hopefully, with on this issue and other issues. And we just saw, a bit of gun reform going through Congress. So that's something. But just a wake-up call to say there are these other branches of government, and we need to expect more on these important issues instead of directing all our attention unhealthily, I would say, for the last few decades. For a while, it was just Justice Kennedy and O'Connor. And then since then, now we're kind of obsessed, would Chief Justice Roberts be the swing vote? And I just think we got to get our attention off like these individuals and really start thinking differently.
Yeah, I would say too that I kind of want to resist the premise of the question a little bit, because I think if you study backlash even to Roe, right, it took a long time to know what kind of popular reaction we would get to Roe. So in 1975, right, John Paul Stevens is confirmed to the Supreme Court unanimously with nary a question about Roe. You have neither political party really caring at all about Roe. So if somebody had talked to you in 1975, they would have said, well, this whole anti-abortion movement is just a dud, right? This is not a constitutional movement that's going to matter. No one in party politics cares. No one really in the medical establishment cares. No one vis-a-vis Supreme Court confirmations cares. And yet here we are, right? So I would say if we want to know the extent to which this is going to catalyze some kind of meaningful constitutional or political mobilization, we may need to look past 2022, right? I'm certainly doing that. 2022 is a good first take, But I think we know from Roe and from the past 50 years that political mobilizations that matter to our constitutional order sometimes take a while to get going. And that's been true comparatively to in other countries. Sometimes, to Dr. King's point, it takes people seeing the real world effects of these laws to know that this issue really matters to them, versus kind of more of the abstractions about, a right has been taken away. Sometimes voters don't know what to make of that until they see what it's doing in their own lives. So I would say, to know what the politics of this will look like, we may need to look certainly at 2022, but also beyond it.
So I'm going to jump in now here. We've had 83 questions in the Q&A. Apologies to many people's questions we haven't been able to get to, but I do want to leave us with one last question that any of you can jump in on, and that's as follows. So we have a diverse political community at Harvard Law School, but certainly a subset of our students are understandably incensed by this decision and want to know, what should they be doing right now? What areas of law should they be spending their time on? What should they focus on? What kinds of advocacy? What would you tell students who ask you this question?
Well, from a very practical standpoint, the suggestion that we could create access on federal land, by the way, it wouldn't work, because you'd be asking, again, that same issue, right? I can fly in there and I can provide that care, but at the end of the day, I then have to send that person back into a place where she or they might be unsafe, or he. But by contrast, there are well-established groups that are mobilized, ready, have been planning for years to provide the funding necessary to bring patients to states in which they can access care. And your colleagues over at the medical school are mobilizing and ready to help and trying to find ways to create more and more and more access for people who are coming from out of state. And the same is true in many other parts of the country where access is still guaranteed. In terms of the move forward, I want to see more of our graduates focusing on how to better enshrine our voting rights so that the actual voice of the people is heard in DC and around in each state, because I don't believe that this result actually reflects the true voice of the American populace. And I think that's a function of the fact that we don't have voting rights that are well enshrined, as evidenced by the recent shadow docket opinion. So if you're going to work on anything as a lawyer right now, I'm hoping that many of you will choose to really work to get a more democratic process in play in the United States so that our laws actually reflect what the majority of people believe. That's not to say that I don't understand that there are a minority of people in this country who are happy with this decision and come to that belief that this is a good and valid and moral decision, honestly, but they do represent a minority. And we still need to have a country that works for at least as many of us as possible, if not the majority.
I think obviously a lot of what we've been saying has been that there's a lot of action in the states now. This has been an area that I think conservatives have succeeded in to a much greater extent than progressives, so I think that means state elections. So kind of being aware of issues surrounding state elections. That may be on the kind of public interest litigation side. It may even be on the political side. There's a lot going on now with state constitutional litigation in this arena. I'm particularly watching Michigan, which I think is sort of the greatest test case for new potential state constitutional protections. That's going both ways, right? We've seen in Iowa and Florida states that once had constitutional protections, either in the case of Iowa already being eliminated, in the case of Florida, I'm here to tell you likely being eliminated, although that hasn't happened yet. I think focusing on what these rights look like at the state level is going to be crucial. And I'm interested too, and I think this is something that someone should, if not me, someone should start some sort of direct democracy project on this too, because we have reason to believe that in states that are conservative, we are not sure if people are disaggregating partisan preferences from preferences on abortion, which is to say there are a number of states where people's preferences for conservative candidates outweigh their direct preferences on abortion. So in Oklahoma, for example, we have pretty reliable polling that a majority of voters would not want abortion to be illegal. And yet we have a governor who's saying quite literally, I will sign any abortion law that crosses my desk, who's signed several complicated and confusing and at times contradictory abortion bans simultaneously. So I'd be curious, and I would hope too, that people would, with differing views on abortion, would like to live in a world where voters got to decide directly instead of having to have their views mediated by their partisan preferences. So I think that's another area that's promising, and it's an area in Europe that's shown sometimes the capacity to de-escalate conflicts within and between states. So that we've seen some of this happening in red states like Kansas and purple states like Michigan, but I would think that that's something that would be a promising area of activism going forward, because it would at least give people directly, if democracy is truly what the Supreme Court is after, there's no reason that democracy should be purely mediated by partisan politics. It could be something that's taken directly to voters and separated from partisan politics.
I think we're going to have to let that be the last word. Thank you all to the panel, and thank you all for the attendees, and have a good rest of your day.
Thanks, everybody.